Please rise. The Justices of the Appellate Division, Supreme Court, First Department. May hear you, all persons having business with the Appellate Division. Draw near, give your attendance, and you shall be heard.
Good afternoon, lawyers. Great to be here in person. Welcome to the Appellate Division First Department. I will begin with a call of the calendar. People versus Jeffrey Pierre. Appellant Pierre gets 5 minutes and 2 in rebuttal. The people get 5 minutes. Rosado, you may be seated, counsel. Let me just go through the calendar and then we'll go into the first case. Rosado versus NYCHA. Appellant Rosado gets 5 minutes and 2 in rebuttal. Respondent NYCHA gets 5 minutes. C Children is submitted. Nation Star Mortgage versus Ame submitted. People versus Webster. Appellant Webster gets 6 minutes and 2 in rebuttal. The people get 6 minutes. Rome Capital versus Asia Alternatives. Rome Capital gets 5 minutes and 2 in rebuttal. Respondent gets 5 minutes. People versus Dilbert and Kookie and People versus Hrynenko. Appellant defendants get 6 minutes and 2 in rebuttal. The people get 6 minutes, and I understand they'll be argued separately. Principia Partners versus Swap Financial and Syncora. Appellant Principia Partner gets 6 minutes and 2 in rebuttal. Swap Financial and Syncora each get 5 minutes. Steinberg versus Steinberg is submitted. Almonte versus Edgecombe Property and 535 Phase. Appellant 535 Phase gets 6 minutes and 2 in rebuttal. Respondent Almonte gets 6 minutes. Now, 2 cases that will be argued together, Gibson Dunn versus World Class Capital, and case numbers 00104 and 04806. Each party will get 8 minutes and 2 in rebuttal, since there's 2 cases in which different ones are appellants. Hogan versus 590 Madison is submitted. Citigroup Global versus Fiorilla is submitted. Miranda versus River, Hanover River is submitted. And Ringel versus Roganiski is submitted. On Ringel versus Roganiski, Justice Shulman will be recusing, and Justice Barbara Kapnick has been vouched in. Also, appeal number 6, Rome Capital versus Asia Alternatives, I will be recusing in that case, and Justice also Barbara Kapnick has been vouched in. In that case will be argued. But first case on the calendar is People versus Pierre. Let me hear from appellant Pierre.
May it please the court, Robert Dean for Jeffrey Pierre. My client is doing 9 years in prison, which is 2 years more than the minimum, for possession of a gun outside his home or place of business. He's the second violent felony offender based upon a robbery of a $5 bill from a childhood friend when he was 16 years old. Now, he has a record, but that's his only prior violent felony.
Well, Mr. Dean, I understand that he is a second violent felony offender. and that sort of aggravated and went to the 9-year sentence. You said that the minimum is 5.
I think, no, the minimum, I believe, is 7, but
7, okay. That I wasn't clear because at some point in your brief I
Right.
saw 5. So the minimum legal sentence is 7.
it's 7, yes.
Okay.
But, counsel, I just wanted to be clear. You said he was, your client was convicted of the possession of a weapon. It wasn't straight possession. It was possession with the intent to use unlawfully, was it not?
No, it was possession outside of his home of place of business. He was never charged with possession with intent to use unlawfully.
So, but it was, I thought it was CPW too.
It is CPW too. Possession of a loaded firearm outside of home of place of business is a Class C violent felony. That's what he was charged with, and that's what he was convicted of. He was never charged with possession of the gun with intent to use unlawfully.
I know part of the argument was that the possession was temporary.
I'm going to get to that. Right. So he was acquitted of all the homicide charges based upon self-defense, and thus the jury found that he was not the initial aggressor, and he could not have retreated with safety. So he's doing 9 years for possessing a gun for 2 minutes that a robber had just used to rob him and hit him over the head with. So even if he's guilty, the sentence is excessive, but he's not guilty, and I'd like to explain why.
He's not guilty of the possession?
He is not guilty of possession based upon temporary and innocent possession of a weapon, and I will explain why. So the jury made a mistake. Now, usually we don't know why a jury makes a mistake. We say this all the time, but we're usually speculating, what is the jury thinking? But here we know, because in the defense counsel's pre-sentence memorandum, which is before the court and part of the record, it says, and I'm quoting, defense counsel had the opportunity to speak with 10 of the 12 seated jurors after the verdict in this case. In explaining their decision, those jurors indicated that the basis for the decision to convict on this count was that they found Mr. Pierre could have avoided picking up the gun from the street. So that's where the jury made a mistake, because that's not the question of whether he could have avoided picking it up. You know, if John Q. Citizen comes along and there's a gun on the street.
I didn't see any of this. I didn't see any of this in your brief.
We arguing, I did a reply brief all on temporary innocent possession.
But did you argue
What
anything?
I just quoted is in the record. I didn't put it in my reply brief, no.
Because I didn't see any argument that there was any issue in terms of the, ineffective assistance to counsel. I thought the basis of that was the failure to request a justification charge.
Right.
I didn't see anything about ineffective assistance to counsel based upon any conversations that counsel had with the jury following the verdict or anything of that nature.
Right. I'm telling you now, it's in the record. Point 1 of our brief is that he was not guilty based upon weight of the evidence, based upon temporary innocent possession. I'm just explaining to you, for the court's benefit, so it can exercise its interest of justice jurisdiction based upon what's in the record, that the jury made a mistake because they thought he could have avoided picking up the weapon, but that's not the question. John Q. Public, if they come across a weapon on the street and they intend to pick it up and immediately turn it over to the police, they could have avoided picking up that weapon.
Was there also not testimony that he had a weapon, a similar weapon, the .40 caliber in the glove compartment of his vehicle?
Absolutely not. Absolutely not.
There was no evidence that he was seen in at least one of the videos pull a pistol from behind?
No. In fact, the court asked our office for People's Exhibit 5, which is that surveillance tape.
Right.
And the surveillance tape is absolutely consistent with his testimony. It shows the middle of the chase along a darkened street. And first to come around the corner is Johnson, the guy who originally had the gun. And he's just carrying all the defendants, his computer, his phones, his mother's Home Depot card, everything. He's running. And behind him is Lewis, who was found ultimately with a gun, and he's waving a gun. And then the defendant is coming around the corner, and he's got a gun, but he's not waving it. And there was no gun in his glove compartment because they took everything. They took everything, including his mother's Home Depot card.
Including his car keys.
And his car keys, and his home keys, and his ID with his address on it. His home keys and his ID with his address on it.
Okay.
Well, obviously he's upset, and he's chasing after these guys who had just robbed him and hit him over the head. And so he sees the gun and he picks it up. So I'm asking, is that so unreasonable that he has the gun for the next 2 minutes,
Okay.
and now he's guilty of possessing a gun?
Okay. Thank you, Mr. Dean. Let me hear from the people.
May it please the court, Noah Shamoy for the people. Your Honor, briefly, as to the sentence, 9 years, 2 above the minimum for a second violent felony offender was eminently fair. Defendant's possession of the firearm resulted in the deaths of 2 people.
But he was acquitted. He was acquitted on the homicide charges.
Right.
He admitted that his possession resulted in this, and it was his unlawful possession of it that caused their deaths. They robbed him, it's true, but he could have called the police. If he was concerned about his family, he could have gone the opposite direction.
But again,
7 blocks.
we're not concerned about that because he was, the jury acquitted him of the homicide. They acquitted him on the 2 homicides. So what we're concerned with is solely the possession of the weapon and whether the weight of the evidence supported that or whether it did not support that, and whether the sentence imposed was excessive or not.
Yes, Your Honor, but as to the sentence, these are factors the court can consider because they don't go to disproving what the jury found. They go to whether or not his actions were appropriate in light of the unlawful possession of which he was
Well,
convicted.
this guy, he's patiently waiting for his girlfriend who just went to get something. These guys appear, point a gun at his face, hit him over the head with it. The other guy goes on the passenger side, takes all of his personal possessions, including the keys to the car.
Yes,
What is he supposed to do?
well, there were
At
4.
least,
There
I
were.
want to say not part of the South Bronx, but anywhere.
The problem is there were 4 individuals. There's a car parked right behind them with its headlights on that had just pulled up. There was a bald man. It was all on surveillance video standing right there. There was the deli employees and his friend, all of whom were right there that he could have asked for help. He knew that some had phones because his friend had called.
So he has a gun pointed at him, or you mean after?
I mean, when they leave, and instead of him chasing after them, he had options. And he chose not to use any of those reasonable options. And yes, the lesser of 2 evils defense, that does answer that, of course. But it also
But
goes
of course,
to
the jury thought that it was reasonable in as much as they didn't find him guilty of murdering the 2 men, right?
Well, as the defense brief points out, it's actually unclear exactly the grounds on which the jury decided his actions were, quote unquote, reasonable.
Jurors do
Nullific-
mysterious things, right?
That is true. However, what we do have is, and the video surveillance does show this, is that his testimony can't be reconciled with the objective facts that are presented.
So I thought the
And-
video showed him making a motion to the small of his back or his waistband and pulling out a gun. Your adversary just stated that that's not correct.
It is on the video, Your Honor, as he turns onto Roundabouts Avenue, he crosses the street, there's a van, he is coming up behind the van, he goes like this as he's running, he brings his arm back out. 2 seconds later, as he crosses back in front of the van, his right hand has a black L-shaped object in it.
So was that consistent with his testimony that Lewis, I don't know which one, Lewis or Johnson, dropped the gun, he picks up the gun, places the gun in his waistband, and then continues to chase? And so on the video where we see him removing the gun, that's because he had just picked it up from where Lewis or Johnson had dropped it?
We cite to the exact page in our brief, but he explicitly denied having the gun in his waistband. He said that didn't happen, he picked it up, and it never left his hand. And he made sure to say that this dropping of the gun took place on the only section of a block that didn't have video coverage.
So the jury found them not guilty of any of that,
So the
right?
jury found him not guilty.
Except for the criminal possession of a weapon in the 2nd degree.
Correct. And as for temporary and lawful possession. Our point is he had 15 seconds to find a concealed weapon in his car. We don't know where he concealed it. He waited to chase after them. He couldn't explain that. His DNA is the only DNA found on the gun. As I said, he reaches into his waist to get it, and then temporary unlawful possession does have an element that you actually have to either dispose of it safely or turn it in, which even without everything else, that alone is enough to convict him. When he, instead of going to where he knows the police are, which is approaching his own SUV, he goes in the opposite direction, down a street he's hoping no one will find him. Once he sees a police car coming up slowly up that block, heading towards his own SUV, he slows down, does a gesture that was described as this, if I may continue and finish.
You may.
Does a gesture described as this at trial, which is just tossing to the side, then puts his hands in his pockets and slows down even more as to not get the police officer's attention, which under the law is alone sufficient to convict him of this crime, because he was not attempting to get the officers.
Why 90 years instead of the minimum 7, given inasmuch as he was found not guilty of the actual?
I was very confused by my adversary. He actually has 2 prior violence. He has a rob 2 and an attempted rob 1. One was a YO, one was a conviction. He's served over 9 years in prison aggregate to date for all of his different crimes, which includes more than a half dozen major forgeries and related frauds. He has not learned his lesson, and it seems clear in this case, as the sentencing court said, that he chose to take the law into his own hands, and it was an appropriate sentence to impose 9 years. Thank you.
Thank you. So, Mr. Dean, he either took the law in his own hands or those 2 perps got what was coming to them.
Well, they got what they were coming to them, I'm sorry to say. He was more sinned against than sinning, as King Lear would say.
I'm sorry, what did you say?
He was more sinned against than sinning. It's a line from King Lear. But obviously, the people and I are looking at a completely different People's Exhibit 5, which I did supply to the court. It's totally consistent with his testimony. If the court can see the defendant reaching into the back of his waistband, fine. I never saw that. So I'd say one picture is worth 1,000 words. You should look at that video.
Where's that from? That's a quote from where? But, Mr. Dean, the other thing was, I thought that his testimony was also that when he picked up the gun, he did so something like he wanted to fortify himself or prepare himself for any encounters that he was.
No, he didn't testify to that. He just said it was instinctual.
No, I thought he made some, in reading the record, I thought he said something about he knew that perhaps he was going to need it in terms of an encounter with them.
No, he said the opposite, actually. He didn't testify to
I don't think so. But
Well,
anyhow.
he just said, he was cross-examined a gazillion ways by the prosecutor who was asking him why he picked up the gun. And he didn't say I was going to use it to shoot at these guys.
He said something
it
like
was instinctual.
he thought he might have needed it.
So, Mr. Dean, I hear from the people that your client already has served 9 years based on some other offenses and clearly has not learned his lesson. So please tell me why we should exercise our interest of justice during
Okay, so he had a robbery adjudication as a YO, which the last I know is not a violent felony offense.
How old was he when he committed the crime?
You mean in this case?
In this case.
He was about 34, 35, 36.
34, so why old? So it was 15 years before?
Almost 20 years before was the YO and the robbery of his friend, for which he got robbed too. And he's not a choir boy, but they're all those things are nonviolent offenses, forgery and possession. So we're just saying that under the circumstances of this case, 7 years, I don't know where this, he hasn't learned his lesson thing. He was robbed, he was hit over the head, he was chasing after the guys, which is, something I wouldn't have done. But these guys had just robbed him and he didn't want him to get away. So he had the gun for a total of 2 minutes. It wasn't his gun.
Okay. Thank you, Mr. Dean. Thank you both. Rosado versus New York City Housing Authority. You know, he just got served to the U.S. Supreme Court.
Oh, yeah?
About things, yeah.
Good afternoon, Your Honors.
Good afternoon.
Please, the court, Brett Friedman for appellant. I expect to be quick here because as I see it, this case really just boils down to conflicting evidence on notice. You have a plaintiff who testified that he saw a condition on the stairs 2 days before the accident, and that condition, the same one, was still there in the same spot when he fell the next Monday. On the other hand, you have an affidavit from defendant's janitor who says that she worked the morning of the accident, she cleaned the steps, and at or just prior to the time of the accident, the stairs were clean.
So you think that, or the argument you make is that Ms. Sanchez's inspection and cleaning of the staircase 30 minutes before the accident conflicts with your client's testimony that 2 days before the accident, she spoke to a housing authority about the grease in the stairs.
That is certainly part of it, but I think the real critical issue is simply that Ms. Sanchez in her affidavit said, I cleaned the stairs, and at noon or approximately noon when I finished, the stairs were clean. And then you have plaintiff who testified not only that he saw this condition 2 days earlier, but that the same condition was still there when he fell. I don't see how you can reconcile those two. Essentially, you would have to decide who to believe, which we can't do on summary judgment.
And you base that, I know you cited to that Nieves case from this court that was just issued a couple of weeks ago. So how does that case help you?
And even if the exact facts aren't accurate, I think what we have is conflicting testimony as to the condition of the steps themselves. When one party says the steps were clean, one party says not only were they dirty, but they were dirty 2 days ago. The fact that plaintiff testified to complaining about it also obviously goes to actual notice, but at the very least, I think we have constructive because obviously the housing authority says we had a regular cleaning schedule. So they had some workers on duty Saturday and Sunday. Now, nowhere in the record do we have evidence from the housing authority as to who worked on Saturday, who worked on Sunday, what they saw, or what they did. Their sole deposition witness didn't even work those days. It was another individual, Desmond Thompson, who there's no testimony or affidavit from whatsoever.
So I mean, you think Mr. Gillespie, the supervisor, is just making that up with respect to what his log says for June 30th of 2014?
I don't think he made up anything in the lot. I just know that he essentially had no relevant personal knowledge of his own, where he said, normally it's the other supervisor of caretakers that would work there, and in fact it was the other supervisor 2 days before the accident, 1 day before the accident, and he said, look, on June 30th, I had to check all 14 buildings of this development. I never make it to all of them when that happens, and he couldn't remember whether at any point he checked this building, even though he admitted he was responsible for checking Ms. Sanchez's work.
Okay. Okay.
Thank you.
We hear from the Housing Authority.
Good afternoon. May it please the court. Patrick Lawless for the New York City Housing Authority. If I may, I'd just like to draw this court's attention to a decision that just came out yesterday. It was a similar case that I argued. The name of the case is Beatrice Villar, V-I-L-L-A-R, versus NYCHA, and involved a similar affidavit from the caretaker, and it also involved the same issue here, where in opposition to NYCHA's motion for summary judgment, the plaintiff submitted expert testimony which conflicted with his deposition that there was some sort of structural defect with the stairs. So in that sense, that decision is relevant. With respect to...
But I thought the argument you make with respect to the expert was that the allegations were not originally included in the notice of claim.
Well, there's several. Number one, it's not in proper admissible form because you have Mr. Fine's affidavit, and he doesn't incorporate the 3101D, which is not sworn. It's not sworn to, and it's not in admissible form. And he doesn't even support any of the claims in the 3101D. He just makes conclusory statements. So you have that it conflicts with the plaintiff's testimony, and you have that it's not in the notice of claim. So for all those reasons, it shouldn't be considered. Now, with respect to the plaintiff's argument, the plaintiff testified at his 50H, and he was pretty clear and unequivocal. He had no idea what he slipped in, and he said in pretty colorful terms, could have been water, could have been urine, could have been feces, could have been grease. I don't know. It was some sort of indescribable greasy substance. Then he turns around in his deposition, and he describes it as some sort of yellow substance, and then he claims it was the same yellow substance that he saw. So I would submit that that's a feigned issue of fact because it directly conflicts with what he testified to at his 50H hearing. Also,
does it really matter since he testifies that regardless of what it was, whether it was urine, whether it was grease, or what have you, he reported that condition to a female worker?
Well, there's another problem with that. Aside from a feigned issue of fact, he also claimed that he reported it to a female NYCHA employee on a Saturday between 5 and 6 p.m.
Right.
You have in the record, you have Ms. Sanchez's affidavit at page 357, and then you have Mr. Gillespie's testimony at 274. Both say on Saturdays, NYCHA maintenance staff is only there from 8 until 1, then they're gone. So he's saying that he spoke to someone from NYCHA 5 hours after they would have left for the day. So that's not possible. That's incredible as a matter of law. And again, it's a feigned issue of fact because he never testified at his 50H that it was the same substance. He testified he didn't know what it was.
Yeah, I mean, clearly a lot of these lacks are really problematic because I understand that counsel is also arguing that although Mr. Gillespie claims that his log for June 30th of 2014 indicated that Sanchez was the janitor that was assigned that day, in fact, that wasn't to the building, to 2275 Randall Avenue, Building 10. In fact, that wasn't the case.
Well, Mr. Gillespie's testimony just confirms what's in Ms. Sanchez's affidavit. She testified through personal knowledge what she actually did on the date of the alleged incident. And all he confirms is that she was assigned to the building that day, that there was a janitorial schedule in place, and pursuant to the janitorial schedule, this is what she was required to do, and she confirmed that she actually did it. Thank you.
Okay.
Just to start off, I want to know if you have any questions regarding defendant's speculation argument, because I don't think it's viable at all, but I'd be happy to answer any questions regarding it.
Yeah, I think we're good.
Okay, so then the only thing really left to touch on is this argument that it's somehow incredible as a matter of law that plaintiff can testify that he complained to a NYCHA worker on a Saturday after 5 o'clock. Not incredible as a matter of law. I think we know in every case where that's been the issue, it involved things that were physically impossible or, as they say, contrary to experience. What we have here is simply conflicting testimony and a credibility issue, and it's only highlighted by the fact.
Counsel, if I may, plaintiff makes the complaint 2 days before. The evidence is clear that after the plaintiff made the complaint, that the stairwell was cleaned. So can it be said that whatever substance the plaintiff fell on that day, that was certainly different than the condition he reported 2 days earlier? How could they have notice?
Respectfully, I think the record shows that that wasn't the case. While Ms. Sanchez certainly said in her affidavit that she cleaned the stairs, the plaintiff said in very clear terms when he testified that it was the same exact condition on the stairs on Monday as had been there on Saturday 2 days earlier. That's the key conflict here. Had plaintiff said it was a different condition, or yes, the one from Saturday had been cleaned, it may be a different story, but plaintiff was very clear that it was the same condition. And I could cite to the pages on the record if you'd like. Specifically, I see at 212 to 213, and then at other places as well, but I see that I'm out of time here.
Thank you, counsel.
Thank you, Your Honor.
Thank you both. Next case for argument is People versus Webster.
Good afternoon, Your Honors. Marini Nevitt, legal intern with the Office of the Appellate Defender, on behalf of Mr. Terrell Webster. May it please the Court. Mr. Webster was placed into 2 lineup procedures wearing a gray hooded sweatshirt, which matched a gray hooded sweatshirt, which was a key aspect of the description given by the complainants of the robber in this case. Not only that, the lineups in this case were filled with individuals that appeared significantly older than Mr. Webster and significantly heavier than Mr. Webster. The detectives arranging the lineups took no efforts to hide or mitigate the scar on Mr. Webster's face.
I'm sorry, go ahead.
But you couldn't see the scar, right? I mean, I saw the photo in color, and other than staring red pair of pants of juror number 4, there was really no distinct. I mean, you couldn't see scars in any of them. I understand that the victim was wearing a gray hoodie that was part of the description of the robber, but that looked like a pretty straight lineup.
Your Honor, looking to the totality of the circumstances in this case, for example, especially the gray hoodie, which was a key aspect of the only 3-part description that the complainant gave of the robber, and that description included only a gray hooded sweatshirt, which Mr. Webster was wearing, or which matched the sweatshirt Mr. Webster was wearing in the lineup, sweatpants, and a black jacket with colorful patches. One of 3 of those.
In the lineup, he wasn't wearing a black jacket with colorful patches.
That's correct, Your Honor. I'm sorry.
And also, what I was going to say in terms of the scar, the 2 complainants, neither one identified the individual or described the individual who robbed them as having a scar. So that was not part of the description given.
The scar was not part of the description. The jacket, the gray hooded sweatshirt, was part of the description. And then Mr. Webster looks significantly younger than at least 3 of the other.
But you agree that the jacket in the lineup was very different than the jacket that was worn in the surveillance camera video, right?
Mr. Webster was not wearing the black jacket, which is part of the description in the lineup. That is correct. Mr. Webster is wearing a gray hooded sweatshirt, which was part of the description and which can also be seen in the surveillance video.
And so when we have the video or the photograph of the lineup itself, and if you look at it, why would you say that it is any way suggestive? I mean, I recognize you argue that there's a variance in terms of age. I think there was someone who's 30-something years of age. In terms of weight, you just mentioned. But it's a seated lineup, and you look at everyone, and as you stated, it's the totality of the circumstances, so why would you say that it's suggestive?
Yes, the gray hoodie combined with the differences in age, the differences in height, which the detective...
Seated. They're seated.
That's correct, but the detective actually at the hearing even acknowledged that even when individuals are seated, you cannot mitigate entirely for height differences.
But we can look at it. But
That's
we
correct,
see it.
Your Honor.
So, I mean, it's not an issue in terms of not being able to mitigate for it, but we actually can see as they are seated whether there is any real issue in terms of any height differential.
When we look to the totality of the circumstances in this case, both the height, the age, the weight, all of those things serve to rule out certain individuals, and the gray hooded sweatshirt unduly points your attention and would single out Mr. Webster for identification. I'd like to turn now to Mr. Webster's 20-year sentence. Mr. Webster was only 20 years old at the time of these robberies, and he received a 20-year sentence, which was equal to the entire time he had been alive. A just sentence is a sentence that accounts for both the underlying facts of the crime and the individual circumstances of the person being sentenced, without at all diminishing the seriousness of the crimes in this case. It should be recognized that no one was physically injured or killed in the course of these robberies, yet a 20-year sentence is a sentence we might expect to see in a case involving serious injury or death.
Well, I mean, there are 2 gunpoint robberies, right? I mean, he was given 10 years consecutive, so 10 years on each for each. But we're talking about 2 gunpoint robberies. And I recognize your argument that no one was injured. He did approach these 2 individuals, and displayed a weapon, a gun.
Your Honor, we're not trying to diminish the seriousness of these crimes, but the reality is that Mr. Webster was given 2 consecutive 10-year sentences, as you mentioned, when he could have received a minimum of 8 years concurrently. Mr. Webster is serving a sentence that is more than twice that minimum sentence that he could have received.
So 8 years was the minimum sentence for each robbery, right?
8 years was the minimum for each robbery, and so those could have been run concurrently rather than consecutively.
Okay, thank you.
Thank you.
Let me hear from the people.
Good afternoon, Your Honors, and may it please the Court. Samuel Goldfein on behalf of the people. Unless Your Honors have any questions about the lineup, I think the picture speaks for itself. The lineup was fair. Everyone looks reasonably situated to the defendant. As far as the sentence goes,
I wish that the gray hoodie would have disappeared, right?
I understand, Your Honor.
That was part of the description. So although everybody else was, not everybody, but most folks in the lineup had hoodies on, they were not gray. Right.
That's correct, Your Honor. I mean, defendant's hoodie is also, it's gray with blue sleeves, which was not part of the description, and also a generic item of clothing this court has ruled several times. Turning to the sentence, yes, 20 years is a long time, but as Your Honors pointed out, he committed 2 gunpoint robberies, minimum 8, maximum 25.
What was the pretrial offer?
Pretrial, he was offered 8 years, Your Honor. That was also 8 years.
8 consecutive or 8 concurrent?
The only evidence on the record is from defense counsel at the sentencing, but it appears that he was offered 8 concurrent.
So we went from 8 concurrent to 10 consecutive.
Yes, Your Honor, and there's a number of reasons for that. First and foremost, defendant absconded for the entirety of the trial.
I'm sorry?
Defendant was in absentia for the entirety of the trial, the hearing, sentence as well. He had to be brought in involuntarily. Also, the people at the time the offer was made were uncertain about this case. One of the witnesses is from Morocco in Africa, and also both the victims had to come in and relive a trying experience. I don't think there's any justification to run the sentences consecutively here. He committed 2 gunpoint robberies and should receive punishment for both of those crimes. Also notable
20 years old, right?
I appreciate his age, Your Honor, but also he's 20 years old at the time. He had a previous first-degree robbery conviction. He received a youthful offender adjudication on that, but he was still out on probation at the time that he committed 2 more first-degree robberies. I mean, the PSI indicates as well, this is a violent individual. His conduct seems to be escalating. He doesn't seem deterred by prison. So respectfully ask that you affirm his sentence.
Okay. Thank you.
A 20-year sentence fails to account for any of the data showing that adolescents must be considered less culpable than adults when we're talking about criminal sentencing, and that they're more amenable to rehabilitation than adults. Counsel referred to Mr. Webster's previous conviction for third-degree robbery, but the reality is that Mr. Webster was younger at that time, I believe in 2014, than he was when these robberies took place, And Mr. Webster was susceptible to all of the things that we know to be true that both the Supreme Court of the United States and the New York Court of Appeals have recognized about brain development and youth and impulse control. Parts of the brain that are involved in behavior control continue to develop until the early and mid-20s. Mr. Webster was squarely in the middle of that time period, both at the earlier robbery and then at the time of these crimes. Mr. Webster, as a 20-year-old, is more amenable to rehabilitation than an adult, and even if he were to serve 10 years, he would be in his 30s and will have well aged out of the time of youth in which he would have been susceptible to being unable to control impulses or understand long-term consequences. So even if Mr. Webster serves 10 years, he will be 30 years old when he is released on these crimes. Mr. Webster is also not just any 20-year-old. He is a 20-year-old that had a rough family history. We've described in our briefs how Mr. Webster was treated as an outcast in his family and how that had severe effects on his mental health, how he was diagnosed with bipolar disorder as a teenager, and he was hospitalized at least once for an attempt to take his own life. This court now has the opportunity to look to Mr. Webster's age, in addition to these family circumstances, and recognize that 20 years for these crimes is harsh and excessive. For these reasons, and for the reasons stated in our brief, we ask that Mr. Webster's sentence be overturned, or in the alternative, that his sentence be reduced.
Okay, thank you. Counsel, thank you both. You're an intern with a appellate defender?
Yes, Your Honor. I'm finishing law school right now.
Okay, you going to school in the city?
Yes,
Okay,
at NYU.
So I assume you're going to take the bar for the first department, right?
I actually am going
The
to
answer is yes to
Yes.
that.
And I'm sorry, you said you were attending what law school?
NYU.
Thank you very much.
Not Columbia.
Thank you, Your
NYU,
Honor.
better.
Nevertheless, I assume you're going to get a fantastic grade. So,
Thank you.
thank you both. Okay, the next case on the calendar is Rome Capital versus Asia Alternatives. I have recused myself from this case, and Justice Barbara Kapnick has been vouched in.
Okay. Let me set this up, and you are... Oops, okay, you may begin. Good afternoon.
Good afternoon, Your Honors. I'm Ann Lefevre with Pillsbury Winthrop on behalf of the respondent, Asia Alternatives. With me today is my colleague from our San Francisco office, Blaine Green, who's been admitted pro hac vice. So with the court's permission, he will handle the argument today on behalf of the respondent.
Yes, absolutely. We're aware of that. Thank you very
Your Honor.
much. Good afternoon.
Good afternoon, Your Honors. It's nice to be in a courtroom again. This is my first time.
Yes.
May it please the court, my name is Ann Champion from Gibson, Dunn, and Crutcher for Rome Capital. The lower court prematurely dismissed this case, leaving Rome without a remedy for Asia Alternatives' blatant violation of the parties' contract and circumvention of Rome, an award-winning placement agent that took a chance on Asia Alternatives on the understanding that the parties would have a multi-fund arrangement, as reflected in Section 7H of the parties' agreement. While the Supreme Court made several errors here, there is only one that this court need address. Should Rome have been permitted to amend its complaint? If the court's answer to this question is yes, it should remand for further proceedings on the proposed amended complaint, and it need not reach other issues on this appeal.
Counsel, did you even need to make a motion to amend your complaint below, or could you just have amended as of right?
Your Honor is correct that Rome could have amended its complaint as of right because it sought to amend during the time that Asia Alternatives' motion to dismiss was still pending. The law is crystal clear on this. NYCHA v. O'Flaherty, 71 AD 3D 533. 3025, CPLR 3025, permits a party to amend his pleading once without leave of court at any time before the period for responding to it expires. And
So was the fact that you didn't do that just a mistake that was made by I think you might not have been the counsel. I guess it's easier to say it was a mistake if you weren't the person. But was that what was the problem?
That's correct, Your Honor. It was just an inadvertent error. But in addition to that, the court directed Rome to seek leave to amend. There were 2 conferences with the court over this amendment. At the first conference on January 16th, the court directed the parties to try to work out a stipulation regarding the amendment. The parties went and tried to do that. They were unable to reach agreement. And so they had another conference with the court, and at that conference, the court directed Rome to file a motion for leave to amend. So unfortunately, there's enough error here to go around. Asia Alternatives doesn't dispute that Rome could have amended as of right. It doesn't dispute that because it can't. Instead, it argues that Rome waived or failed to preserve this right. But Asia Alternatives cites no case in which any New York court has found that a party waived or failed to preserve amendment as of right by mistakenly filing a motion.
Yeah, I didn't, could you address that a little bit more? The defendant is claiming that you waived your right to amend by moving for leave to amend.
Yeah, I find this to be a confusing concept because it's hard for me to see how a party could be deemed to waive a right that they're seeking to exercise by filing a motion. The fact that a party made a mistake as to the procedure for exercising that right does not seem to me to be a fair basis to find waiver here. So, yes, they rely on waiver and failure to preserve. I don't think either of those concepts apply here, and there's no case law to support it. What we did find was a raft of case law, if you look at page 28 of our opening brief, in which courts deny as unnecessary motions for leave to amend that are filed when a party still has an amendment as of right. That is what the court should have done here. The court did not do so, and that was error. And the case should be sent down for proceedings on the proposed amended complaint on that basis alone. But even if leave had been required, Rome easily satisfied the permissive standards for leave to amend. And in denying Rome leave to amend, the court waded into disputed issues of Colombian law regarding which it acknowledged it did not have sufficient evidence and resolved those issues, which is also not permissible on a motion for leave to amend.
So it was your position that even if we got to that point, which you don't think we need to get to, that there was enough in the affirmation that was submitted in connection with the proposed amended complaint to at least support it getting past that first step and getting into the litigation.
Yes, Your Honor, I would actually submit that there was enough in the proposed amended pleading alone, but the Colombian law expert also said in his affirmation that Rome had a claim that Asia Alternatives had made a commitment to use its services for Fund 6. That's at R471, the last paragraph of his affirmation. He said Rome had a claim. That was the evidence in the record. But as Your Honors know, the standard for leave to amend is very permissive. Rome set forth specific Colombian statutes in its pleading, principles of Colombian law, and laid out the facts that supported those claims.
Okay, well, you'll have 2 minutes on rebuttal if there's anything else you want to bring up at that time. Counsel?
Good afternoon, Your Honors. May it please the Court, Blaine Green for the respondent, Asia Alternatives. I'm going to try to address the the arguments made by counsel for Rowan.
Well,
in
counsel,
order.
again, what I did not understand was your argument that plaintiff waived its right to amend by moving for leave to amend. I took a look at the cases that were cited, and I didn't really see how they supported that conclusion or that argument.
So the cases support the general proposition that, where a party has a right and doesn't exercise that particular right, doesn't raise the issue in the trial court, doesn't give the trial court an opportunity to correct the error, then the issue is waived. And that's the situation we have here. The correspondence is quite clear. It was Rowan that sent the letter to the court stating to the court that they seek leave to amend and will file a motion to amend. The court, what the appellate division role is, of course, is to reverse for error. There was no court error, and Rowan's counsel makes it sound like the court directed, had a mistaken or erroneous directive to Rowan. The court never did that. It was Rowan that told the court it was going to seek to amend. The only time the court stepped in was in connection with the proposed motion. Why don't you confer with opposing counsel as to whether opposing counsel will stipulate if you're going to bring this motion? But it was Rowan's decision to bring the motion. Under 3025 of the CPLR, A and B, the statute is clear. Rowan had two options. Under A, it may amend as of right. Under B, it may amend by leave. It chose A. There's no error for this court to correct by the Supreme Court.
Well, counsel, I mean, you certainly agree that Rome certainly was entitled to amend its complaint as of right, correct?
We agree.
Right. And so the next question is, because I agree with my colleague, Justice Weber, that the cases that you cite are totally inapplicable here, because we're dealing there with objections to trial rulings and jury instructions. So what other case law, because I didn't see any, that indicates that the appellant waived the right?
The courts make clear that an issue is not preserved if it hasn't been raised in the trial court, and the trial court has to have the opportunity, and we cite this case in our respondent's brief, the trial court has to have the opportunity to correct its error.
Which is even different provisions of the CPLR, which is not what we have here.
Rowan has not cited any case which says that a trial court is required to advise or correct a mistake by a plaintiff, which is what appellant contends here. Appellant contends that the trial court was...
It seems kind of that neither side cited any cases that are exactly on point. Maybe we just haven't had one that we can find where they certainly had the right to amend as of right. Nobody thought about that at the time, the plaintiff, the defendant, or the judge, and you went to the next step by making a motion, by their making a motion for leave to appeal, for leave to amend, which the court denied. And the question is, did the fact that they made that motion and went that route waive their right to now argue that they should have been allowed to, they should have been able to go the 3025A route? Did they lose that opportunity because they maybe made the motion that they didn't need to make below?
Yeah, Rowan makes the argument that, in fact, that yes, two things. One, they contend this was a mistake. They never made any argument to the trial court that they made a mistake, never sought relief for having made a mistake. And I would submit to your honors that they were represented by two highly experienced law firms at the time, Holland & Knight, Greenberg Traurig. This was 2 weeks after after the court had heard a motion to dismiss on which the court indicated on the record she was likely to grant the motion to dismiss, and they sent a letter to the court saying, we want leave to amend. We're not ready to file right now. We want to do it in 30 days. Please don't actually rule on the motion to dismiss. Don't waste judicial resources. I would submit to your honors, since there is no evidence in the record as to whether this is truly a mistake, there's no declaration from prior counsel. That was a strategic move by Rome to prevent the court from deciding the motion to dismiss against it. Stop the clock. We're going to file a new complaint. They could have simply filed an amended complaint at that time. They chose not to. They get a strategic advantage, and it would set a bad precedent if this court were to order the Supreme Court to allow the amendment now, not correcting any error by the Supreme Court. It would be a bad precedent because it would incentivize every plaintiff who seeks to amend in the trial court to simply move to amend, and you get two options.
I kind of don't know if I agree with you on that. I don't see that.
I know you're over your time, but I'm kind of, so what you're saying is that we here in the appellate division, that on appeal, we don't have the ability to correct the error, because there was an error made by the trial court because the trial court did not arguably recognize that they could have appealed as of right. So was that not an error on their part, on the trial court's part?
The court never made any ruling or gave any direction that Rome could not amend as of right. Never said that.
That never came up.
It never came up because Rome never asked at any point in the proceedings, even all the way up to the hearing when the court denied their motion to dismiss.
So that would not have been an error on the court's part by not recognizing that actually they had the right to, that they could have amended as of right. That does not constitute an error on their part, which we could therefore correct?
It was not an error on the Supreme Court's part because the CPLR makes clear it's a may. Rome has the option under both A and B. Under A, it may amend as of right. Under B, it may seek leave to amend. It doesn't say the plaintiff shall or must amend as of right if the other side hasn't responded yet. It simply has these two options. It chose A. The court never said it couldn't, it chose B. The court never said it couldn't do A. It never tried.
Okay, I think we got it. Thank you very much, Mr. Green. We'll let counsel for the plaintiff has 2 minutes in rebuttal. Thank you.
Thank you, Your Honors.
I would like to address counsel's point that this was strategic. I mean, I think that's crazy. If you file an amended pleading, it would moot that prior motion to dismiss. There would be no reason to decide it. The amended pleading supersedes the prior pleading. So the idea that Rome would have gone out of its way to seek to file a motion when it could have just filed an amended complaint on purpose as a strategic matter just makes no sense. It could have accomplished what counsel contends we were seeking to accomplish, stopping the so-called clock on the motion to dismiss, simply by filing its amended pleading. So there was no strategic motivation here. It was a simple mistake. And I also take issue with counsel's assertion.
But was it a mistake or an error on the court's part, on the motion court's part, or was it simply an error on your part in terms of the way you argued before the trial court?
I think it was both, Your Honor. And if you look at page 28 of our brief, you'll see how courts deal with this. I find the notion that the court is not obligated to apply the correct law, even if a party cites incorrect law, to be just blatantly incorrect. Of course the court has to apply the correct law, and courts routinely correct parties when they assert incorrect law. The fact that didn't happen here, that was an error. It's unfortunate that Rome's counsel made the mistake too, but it was an error for the court not to apply the correct law. It's well accepted that the court has no discretion to deny amendment as of right. The court noted this in its own order. There's no discretion to deny amendment as of right. And when parties mistakenly seek leave, courts routinely deny those motions and say that motion is unnecessary moot, page 28 of our brief, of our opening brief. So again, was it an error that the party shared in? Yes, but it was also an error on the part of the court.
Well, that was perfect timing, I think.
Perfect.
Well done. Thank you both very
Thank
much.
you.
Have a nice afternoon.
Strategic.
You got it. People versus Kookie and Hrynenko. Yeah,
Good afternoon,
I
Your
assume
Honors.
some of the arguments are going to be the same, so that's
Well,
why I called
would-
you up at the same time.
I appreciate that. I was going to make that application, actually. Mr. Michel and I have agreed to divide the issue so as not to be repetitive. I will address the jury question, and he will discuss the sufficiency and weight of the evidence. My only suggestion is that he go right after me, and then Ms. Wertheimer can respond to all the arguments together, but that's up to the court.
Okay, I'm fine with that.
Okay. Your Honors, on this appeal, it is our submission that the CPL 270.30's two-hour rule is only applicable when there is uncertainty about an absent juror's return. District Attorney does not question preservation of this issue, so I'll confine my remarks to that premise. Trial counsel for Mr. Kupik, joined by other counsel at the time, said, quote, "I don't think we have a 270.35 situation, which I think is geared at a juror who is inherently unreliable, does not show up for court, and who is unreliable and runs the risk of derailing the proceedings." He indicated that in this case, we have an incredibly reliable juror. She's done the right thing, and she's accommodated our schedule, and we have chosen her. So my argument today involves what I submit to do to the court as a deep scrutiny of the statute and the relevant case law.
But was it clear that Juror Mims was not going to appear on that Tuesday?
She was going to, was requested that she be allowed to take off the next day to go to Albany for a job interview, and she would absolutely return the following day. The most important point, as I will stress, is that she was not absent. She was in court at the time.
But yes, but the cases as well as the statute makes reference to unavailable for continued jury service. And it was clear that she was going to be unavailable for continued jury service in that she was going to be absent that day because she had to take the mandatory examination. And I think there was another day that she also wanted to leave early.
Well, respectfully, Your Honor, I think you need to read People versus Genty very carefully. In that case, which is 20 years ago, the last time the Court of Appeals addressed the rationale of the statute, wholly consonant with our position, the court said, quote, CPL 270.35(2) now permits, once the court has conducted a reasonably thorough inquiry into an absent juror's whereabouts and possible time of return. All three defendants in that case were absent. They were not in court, Genty, Jones, and Artis. 20 years later, just last year, in People versus Lang, the discharged jury was also absent at the time of the discharge. The court reiterated counsel's premise in this case. Quote, the criminal procedure law provides that to determine whether an absent sworn juror may be presumed unavailable for continued service, etc. Based on that clear, what I submit is restrictive language. I submit that when a juror is not absent and a request for only a brief adjournment is made, the statute is not applicable.
Genty deals with the situation where, you know, the trial court can't find the juror. They don't know where the juror is. And so the question is, how long do you have to wait for the juror? And the Genty and its progeny talks about 2 hours. You wait 2 hours, and then if the juror doesn't appear within that 2-hour period of time, you can substitute an alternate juror. But again, the premise, the foundation of Genty and its progeny is that you're talking about unavailability for continued jury service. And in this particular case, it's my understanding that Ms. Mims was going to be unavailable, I think it was a Tuesday, but she was going to be unavailable that particular day, and based upon the schedule of witnesses, it was going to create an issue because of her unavailability.
Again, I submit that that unavailability is premised upon the juror not being in the court, not knowing when the juror is coming back, not knowing how reliable the...
Unavailability means that she's not available. She's not going to be there.
Right.
That's correct. The statute does not apply if that juror requesting the adjournment is sitting in the courtroom. It's not absent.
But the section talks about continue serving. If she's present in the courtroom when the issue gets discussed, and she's explicitly telling you, this coming Tuesday, I have a mandatory exam that I must appear for in Albany, so I cannot show up at all. The question is whether the court lacks the discretion to decide, well, I need that day for trial.
But I'm submitting, Justice Acosta, that that doesn't apply if the juror's in the courtroom.
So what is it?
Look what this...
I don't understand. So it doesn't. So do we wait until Tuesday now?
No.
So Tuesday she doesn't show up. So what do we do?
But she's assuring she will show up. If she doesn't show up, then you discharge her.
No, she's stating that she's not going to be there on Tuesday.
She's saying she needed the day off. Look what happened in People versus Allen. The Second Department reversed on the law. On the law. That's very important. With the finding that the statute was
Counsel,
not...
is she not saying that she's not going to be there on Tuesday?
She is asking for the day off, and she will be back the next... She was assuring the court she will be back the next day.
She'll be there on Wednesday, but she won't be there on Tuesday.
But she's in court when she's making this application. The statute, by virtue of the language in Genty and Page, talks about Gage.
When I read the statute, if you look at 270.35.1, you know, it says, if at any time after the jury has been sworn and before the rendition of a verdict, a juror is unable to continue serving by reason of illness or other incapacity, or for any reason is unavailable for continued service, the court may discharge such juror. So the court has the discretion in the event that a juror is unable to be involved in continued service. The juror is telling you, I'm not going to be here Tuesday. I have a mandatory exam that I must take. I already put it off once. I cannot do it again. What is the court to do? Wait till Tuesday to make a ruling?
No, the ruling is made then. I'll give you the day off. You're assuring me you'll be back the next day. That's what we'll have to wait for. This is precisely what the Second Department said in LN.
This is the First Department. But again, the thing of it is, so at that point in time, your argument is that the judge has absolutely no discretion to say, no, you can't have the day off. And she says, well, I can't come in. So what is the trial court to do at that point in time?
Trial court on that day that she's supposed to return can discharge her if she's not there. That's the remedy.
I see.
One day off. I know it's the First Department. I'm very well aware, Your Honor. I don't want to create a conflict if we can avoid it. And it seems rather clear that the discharge
I don't see the conflict at all. I don't see the conflict.
Discharge juror.
Counsel, I'm speaking. I don't see the conflict. The bottom line is she's going to Albany. She's going to Albany. This is in New York County where the trial is. We know how far Albany is, right? She's going to take a correction officer's examination. The statute is so clear. She's going to be gone for more than 2 hours. Court totally has discretion.
I'm submitting that that doesn't apply. She's in court. In the Allen case, the juror was present in the courtroom. The Second Department said the record does not demonstrate that juror number 10 was unavailable, as that term is used in CPL 270.35. Why is that? Because she's saying, I will only want one day, I'll be back the next day. So the statute does not apply to someone who is available.
Okay, thank you, counsel.
Thank you, Your Honors.
Thank you, Your Honors.
Good afternoon,
May it please the court. My name is Richard E. Michel. and I represent the defendant, Maria Hrynenko. But as Mr. Baker indicated, I will be making the arguments concerning the legal and factual sufficiency of the evidence of guilt as to both defendants. But my primary client is Ms. Hrynenko. After the presentation of what can only be categorized as a massive amount of evidence, including testimony from 70 witnesses, many of whom were expert witnesses, hundreds of pages of mind-numbing testimony about engineering principles and scientific principles, as well as countless exhibits. My client was, the two defendants were convicted of reckless crimes involving reckless manslaughter and reckless assault based on a theory proposed by the government, by the prosecution, that because of an unauthorized gas delivery system, that the explosion took place.
The theory, right, the argument is that your client acted recklessly in building and operating the system that led to the explosion, right?
Your Honor?
And that the explosion was a foreseeable consequence of that.
That's really what the issues are, and that's what I want to discuss, because, Your Honors, this was a system that was put into effect in August of 2014 and functioned for 7 months without incident. Not even the smell of natural gas.
Well, they have been
until the day of the explosion, Your Honor, after the system had been failed by Con Ed and witnesses detected the smell 10 minutes before the government says, Mr. Kookie, turn the gas back on.
It was an illegal system.
I'm
the
sorry.
fact that it worked for 7 months, I don't think really matters when it was an illegal system.
No. It wasn't an illegal system.
It wasn't.
It was an unauthorized system. There is a difference.
It was unauthorized, and the only person that had said yes and that your client accepted was an unlicensed plumber.
No, there was an unlicensed plumber, Your Honor, working under a licensed plumber. This was entirely legal. And the only flaws that were ever cited by the prosecution from the testimony of their cooperating witness, Eric Pacheco, those flaws had nothing to do, Your Honors, most respectfully, with public safety. Not at all. The issues had to do with things like insulation of brackets with rubber or T-screws to avoid diversion of gas. There was no concern, no flaws having anything to do whatsoever with public safety. And the truly remarkable thing about all of this, Your Honors, is that Con Ed schedules 2 inspections, and in both inspections, the lethal element, or what the prosecution contends is the lethal element, went undetected by Con Edison twice. One time, they approved the system with that lethal element.
They approved the unauthorized system that diverted the gas from 191 to 119 to 121?
Your Honor, there are 3 separate systems here. In answer to your question, they did not. They approved the system that had been proposed, and they were going to swing over from the old system.
So I'm talking about the system that was in effect. The unauthorized, according to the people, according to the proof, the allegedly unauthorized system that was in effect. That diverted gas from 119 to 121.
Correct.
The testimony I thought was that it was makeshift and that it was a unlicensed plumber. You're stating that he was working under the supervision of a licensed plumber.
Correct.
So given that is unauthorized, you're diverting gas from 119 to 121, why is it not foreseeable that this would result in an explosion?
Because nobody knew at the time that this system was set up, that the uncapped meter bars where the gas supposedly escaped. And let's also understand, there was no definitive evidence, Your Honor, establishing that that was the cause of the explosion. But let's say it was. Let's say it was. There was no evidence at all that my client or Mr. Kookie, either one of them, were aware that these 4-meter bars were uncapped and at the same time were attached to the unauthorized system.
But isn't that why you should not rely on unlicensed plumbers to do gas work?
Your Honor, most respectfully, Con Ed didn't even see this. Con Ed, which is licensing and authorizing the system, didn't see this. Now, the district attorney is going to say two things. She's going to say that, well, of course they didn't say anything because they didn't know it was connected to the unauthorized system.
And I thought also that there was testimony that Mr. Kookie instructed someone to dismantle or to dismantle this whole setup prior to Con Ed's coming in for the second inspection.
And why was that, Your Honor? The reason for that was because one of them actually believed that what Con Ed was there to do, having previously approved this very system, that what they were there to do was hang gas meters and swing over the system to the new system.
Isn't it a reasonable view of the evidence, and the jury could consider that perhaps the reason why Mr. Kookie told whomever dismantle it so Con Ed doesn't see it is because they knew that it was unauthorized and that it was something that could result in an explosion?
The reason why it was being concealed, Your Honor, had nothing to do with it being explosive. What it had to do with was, this was, as one of Your Honors said, a makeshift stopgap measure to get from the rental of the apartments to the new system. If this were an unauthorized system, it would be closed down, not because of public safety issues, but because it was unauthorized, having nothing to do.
But why wasn't it authorized?
It wasn't authorized, Your Honor, because they already had a plan before Con Edison, which had been submitted for approval. They were awaiting approval of the new plan. So you
didn't, for greed, right? So you didn't want to wait the 6 months that it takes to get the proper installation approved. You want to collect $3,000 worth of rent.
Your Honor, you can certainly take that view.
Well, the jury took that view.
They can take that view, but the fact of the matter is that greed does not equal manslaughter. It does not equal
It does when a person dies, when a young man dies, and others are injured, then it does equal manslaughter. Excuse me, 2 people died.
That's correct. That's properly the subject of a civil lawsuit. In order for my client and Mr. Kookie to be guilty of reckless manslaughter, there must be an awareness of a risk created by conduct which is disregarded, and the defendant engages in that conduct anyhow. Con Ed did not know about those 4 uncapped meter bars, and neither did our 2 clients. And the fact of the matter also is that even if they did, the proof was not sufficient. I would respectfully submit to this court. The evidence was clearly not sufficient to establish the locus of the explosion. With all of the different opinions, beginning with the fire marshal.
Well, that was the jury to decide, right? In fact, one of your experts talked about the source of the leak in the kitchen of the restaurant.
Correct.
Being the source of the explosion. They didn't buy it. That's what jurors are for, right?
Yes, Your Honor.
So they didn't buy your theory, they bought
you as the second jury, that's what you are here to do too. You are to take a common sense look at this evidence and make a determination for your own that this jury was wrong. Look at that evidence that went in. The determination by Thornton Tomasetti, what was that based on? And they admitted it. that they admitted that they made an error in judgment about that main shutoff valve. Their conclusion that the likely cause was the uncapped meters. And what was that based upon? That was based upon the fact was based upon the main shutoff valve being open. They concluded in their report that this main shutoff valve was recovered and it was open. Not so. No evidence of that. None. And in fact, not only did Thornton Tomasetti acknowledge that, but 3 other witnesses independent of Thornton Tomasetti, also including Detective Cohn, who came up with that fancy little chart that showed where all these pipes were going based on Eric Pacheco's testimony. The fact of the matter was that Thornton Tomasetti made their conclusions on the basis of an erroneous assumption, 2 erroneous assumptions, that the main shutoff valve was found, and the second is that it was found in the open position. ATF Special Agent Grotowski said if that main shutoff valve was closed, we wouldn't be here talking about this case.
Okay. Thank you, Mr. Michel. I appreciate it. Let me hear from the people.
Good afternoon, Your Honors. Sylvia Wertheimer for the people. Defendants' egregious circumvention of the rules and procedures for safely using natural gas was decidedly reckless, and the deadly consequences were entirely foreseeable. Just to try to clarify, there were 2 different systems here. There was a system, plainly the defendants knew that they were supposed to get approval for a gas delivery system. Everyone knows that there's incredibly risks to using natural gas. And they submitted a system for review, and that was approved, but it didn't proceed quickly enough for Defendant Hrynenko's liking. Then there was this other system, bringing gas from 119 to 121, that Con Ed was never submitted for review by anybody. They hid it. The defendants hid it.
So that wasn't part of the initial application to the Department of Buildings?
No, the initial application never said we're going to be bringing gas from 119 to 21, we're going to be drilling a hole through the foundation wall, we're going to be putting valves in the middle of a manifold.
They were basically renovations, install new meters for the apartments in the building basement, etc.
Right, and they were going to have, pipes connect and meters at the front of the 121 basement.
And that system got approved?
That system got approved, but that system required Con Ed, because the apartments had been renovated and would be using more gas, that system required an enhanced source of gas. So instead of, there was only a 1 1/4 inch street line, and Con Ed said, now we need to install a 3 inch gas pipe in the street. For that, you needed the approval of the Department of Transportation to give a permit, which they were being very careful. There were delays because there had just been a gas explosion in Harlem. And Con Ed told the defendants that this gas pipe might be ready, the whole thing might be ready by November 2014. But what did the defendant Hrynenko decided that wasn't soon enough for her? She wanted to rent the apartments in July, effective August 1st. There was no reason there was absolutely no reason for her to do that. And to do that, they came up with this entirely jerry-rigged secret system that was never submitted for review. And had it been submitted for review, the evidence shows Con Ed would have realized the danger. The Con Ed didn't realize that the meter bars, I am going to say, the Con Ed didn't realize the meter bars were hooked up to a source of live gas.
And that system is separate and apart from what had been approved by DOB.
Absolutely.
And that had been issue permit to Mr. Kookie and to Trombetta, who was a licensed plumber.
It's an entirely separate system. Con Ed assumed Everything Con Ed was doing was to try to advance that approved system. They had no idea there was this other system, and the system was hidden in a back room. It was hidden in a back room, so when Con Ed came, they didn't see the system. It was a back room. It was deadbolted. Nobody went into it and saw it. It was deliberately hidden from Con Ed.
I thought your adversary intimated that perhaps Con Ed was aware of that second system.
There's absolutely no evidence that Con Ed was aware of that second system. How could it? It was in the back. It was in the back room in the basement of 121. They didn't go into 119, and they were absolutely not aware of that system.
So, what evidence was there that it was this second system, the makeshift system from 119 to 121 that actually caused the explosion?
Okay, I would say the evidence of that was overwhelming, because you have to look at what the idea that explanation not only was supported by experts who had tremendous credentials, in contrast to the defense expert, but it was consistent with what had happened that day. What had happened that day was that Con Ed was coming for an inspection of the approved system. So defendants decided to turn off the unauthorized system to hide it, and then they turned it back on when the approved system wasn't. When the meters weren't brought for the approved system, they wanted to have gas back. So, and within a short period of time after that, within an hour of that, this explosion happened. About 20 minutes before the explosion happened, Kookie goes into the 119, and turns on the unauthorized system. The idea that that could have happened, but that had nothing to do with the explosion that occurred within 20 minutes, just makes absolutely no common sense. And there are also many things. The idea of a kitchen explosion was totally inconsistent with the damage in the basement, with the structural damage in the basement, the damage to the partition wall. Gas rises, it doesn't go down. So the evidence was overwhelming, and the jury properly credited the people's experts. And again, the conclusion, although the valve was not, the main shut-off valve was not recovered, the only reasonable conclusion consistent with the evidence was that it was open. It was not an erroneous assumption. It was a conclusion mandated by the evidence. Your Honor, these two people died, Nicholas Figueroa and Moises Lacan, because defendants created a secret gas system that they kept totally for financial reasons, that they kept hidden from the authorities that might have seen the flaws in the system. They were properly convicted of reckless manslaughter, and those convictions should be upheld. Thank you.
Thank you. Thank you, Ms. Wertheimer. Okay, got 2 minutes rebuttal.
Thank you, Your Honor. On the jury question, I just want to add one paragraph from People versus Allen, where the juror was present in court. Minor scheduling difficulties, including any brief delay which may have ensued had juror number 10's schedule been accommodated, are not meaningful counterweights to the defendant's constitutional right to trial by a jury in whose selection he has participated, citing Jackson and Rosa, two cases where the jurors were absent and there was reversal in those cases.
And to that point, counsel, the substitution of the juror, that juror who was substituted, that alternate juror, was selected by the parties as well. Is that correct?
Sorry, I can.
The alternate juror who was who replaced Ms. Mims.
Yes.
That alternate juror had been selected by the defendant.
That's
as well.
correct.
Is that correct?
That's correct. And I know the Court of Appeals says one can substitute for the other, but that's when the process is done according to the statute. Here, the statute did not apply.
But only because I saw in your brief that there was some argument about the lack of due process, et cetera, and prejudice to the defendant because of the substitution of the alternate juror. But that alternate juror had been selected by the defendant.
Of course, But just as I read from Alen, it's still a chosen juror, and that's the one they desired first, and it wasn't dismissed properly. Now, just one thought on the evidence regarding Mr. Kookie. There's absolutely no proof that he turned on the system before the explosion. The people died as well, Justice Kennedy and Warner Lampert. People died in People versus Roth. The Court of Appeals found no foreseeability of the ignition point and dismissed those charges. In this case, at least the same as here, but at least, at the very least, because as Mr. Michel said, there was no evidence that my client or Ms. Hrynenko were aware that there were open valves, there were open meters, just like Con Ed was not aware. At the very least, it should be a
But there was a reason that Con Ed didn't know, right?
What I'm saying
It was
is,
hidden from them.
since there's no evidence that they knew those meters were open, at anything, it's a failure to perceive. It should be reduced to criminally negligent homicide.
Okay.
Thank you very much.
No, thank you, counsel. Okay, you got 2 minutes, Mr. Michel.
Thank you, Your Honors, and I don't want to belabor the point, and I'll just take the 2 minutes. First of all, the diversion or the movement of natural gas from 119 to 121, while it was not submitted as part of the plans and it was not approved, that is not per se illegal, unlawful, or unauthorized. There was substantial expert testimony that allowed for the possibility of gas lines going from one building to another. So the fact that gas was going from
You can make a makeshift system where you divert gas from one building to another building, and that's not unauthorized?
That's not what I'm saying, Your Honor. What I seem to be hearing was, and I may be wrong, and I may have not been hearing correctly, was that the idea of gas going from one building to another, whether it is pursuant to an authorized plan, that in and of itself is wrong, illegal. That is not the case. It is entirely permissible to move gas from one building to another if it is approved by Con Ed.
It ultimately has to be approved by Con Ed, right?
But
they have to be allowed in the room.
I'm not suggesting to Your Honor that this unauthorized system would have been approved by Con Ed. I'm not suggesting any of that. What I'm saying to Your Honors is that when you're apportioning criminal liability, the defendants have to have engaged in criminal acts, not civil acts. And the fact of the matter is, the movement of the gas from one building to another does not add to the criminality of the conduct. It could have been approved by Con Ed. It just wasn't part of the plan. I'd also like to point out, if I may, that in terms of what went on in the basement, that the district attorney is saying that the evidence, about the consistency of the evidence. What about the fact that there was an employee from Sushi Park who was down in the basement at the time of the explosion, and if the explosion occurred down there and 2 people are killed upstairs, how it is that Ariel Concasti walked out without a scratch? Or look at the testimony of Detective Cohen at pages 1142 and 1143 of the record, where he has shown a picture of a water heater that was down in the basement, a fragile water heater that had a piece of paper attached to it, and nothing happened to it. How does Thornton Tomasetti explain that if the explosion occurred down there, Concasti wasn't hurt, and this meter wasn't affected, and this paper wasn't burned? There's no explanation for that.
Thank you, Mr. Michel. I appreciate it.
Your Honor, can I just say one last thing? I'm sorry.
Go ahead.
That as far as Kookie and turning on the gas, it's true that in real time, the video shows him going into a building, which means he could have gone up to see my client, Ms. Hrynenko, or he could have gone downstairs. But the fact is that even by their accounting, the smell of gas occurs 10 minutes before if he goes down to the basement and turns on the gas. How does that happen? And why is it that Thornton Tomasetti does not do any tests on the first floor when faced with all of that evidence? Thank you.
Thank you. Thank you all. Principia Partners. Now you see why.
I'm proud of myself.
Yeah.
Good afternoon, Your Honors. May it please the Court, Lisa Bentley for the Plaintiff Appellant Principia Partners, LLC. This matter involves two separate motions to dismiss that were both decided in the same decision. First, the trial court dismissed all of the claims that my client Principia alleged against four related parent companies, the Syncora entities. These were both alter ego allegations and a direct fraud claim. Second, the trial court dismissed a fraud claim that Principia had asserted against separate defendant Swap Financial Group.
Okay.
Neither of these conclusions are supported, and they should.
So let's follow that order. So tell me what particularized facts show that all the Syncora entities dominated Swap.
Sure. So those particularized facts were actually listed by the trial court in the trial court's decision. That included officers and directors sharing dual positions at Swap Financial Group and Syncora, a shared address, information that Swap Financial Group and Syncora shared the same phone number, information that Syncora had actually relocated Swap Financial Group into Syncora's office space, information that Syncora and Swap Financial Group are regularly represented by the same counsel. Now, would that be enough, those elements that I just mentioned? Probably not. But there was much more that was alleged than just that.
Right. Hopefully, the parts that were not just the overlapping members of each board, et cetera, but you got to show me or show the court how those entities actually control Swap, right?
Correct. And that pleading, I believe, is also in our complaint. There's information that suggests that it was Syncora that was funding the payments of Swap Financial Group under the contracts.
You say information that's supported, and that's the whole point. A lot of the complaint is upon information and belief.
Some of the complaint is upon information and belief because we're limited in the information that we have available to us. But a good deal of the allegations in the complaint regarding alter ego are not made upon information and belief, and that has to do with the overlapping officers and directors, the shared address, shared phone number.
Office space, telephone number, personnel, and email are insufficient under New York law.
Absolutely, 100%. But
Okay,
in
so
addition,
we take those out.
In addition,
And then we take out the information and belief, so then what are we left with?
what we're left with, Your Honor, is information that Principia received SFG-related email correspondence from Syncora email addresses. Syncora attempted on two separate occasions to renegotiate the SFG Principia agreement. Principia was directed to send its W-9s directly to Syncora, so that Syncora could pay.
But that sounds more like, I mean, you have an underlying contract, right, with Swap?
Correct.
So the question is, how did all these other entities try to participate in, either tortiously interfere or fraudulently participated or aided and abetted in the scheme that we're talking about, right? That led to what? You basically, through 2017, misstating the revenues that were generated by its customers?
Correct, and I think what you're now referring to is the second prong of the alter ego analysis,
Right.
Your Honor. There's a two-prong analysis that needs to be pled in order to meet the alter ego standard. The first prong is that there was complete domination and control over the
But
corporation.
that's why I asked you the question before, right? What evidence is there of domination? Yeah, clearly there's connection here that are unclear to me.
Correct, but again, I think that we meet that standard not by one factor, not by the address, not by the phone number, not by any one factor, but the combination of all of those factors together. Then putting that prong aside and going into the second prong, we're looking at, was this domination used to commit a fraud or a wrong? And again, we make that pleading as well. And one thing that I just wanted to note, and we make this argument in our papers, is that we have this separate issue here that the trial court didn't even apply the standard. The trial court stated that it was applying the CPLR 3016B fraud standard to the alter ego analysis. The trial court said, indeed, CPLR 3016B's more stringent pleading standard applied. However, this court in 240612 Amsterdam Associates, LLC, found the exact opposite. This court...
I don't want you to chase, that rabbit hole, right? So assuming, if it's not the CPLR, not New York law, whether it's Delaware law or Bermuda law, right? Those are the three entities in question, the three jurisdictions in question. You still have to show some sort of domination, right? Some sort of untoward act by the Syncora entities. And the question is, what are those? And I still have not heard it.
Okay, so with regard to the first prong, I think I went through and addressed each of the different points that we allege in the first prong. With regard to the second prong, which is, was the domination used to commit a fraud or wrong against the plaintiff, I would direct your attention to the complaint, paragraphs 189 to 190, paragraphs 201 to 202.
I looked at those. Let me ask you one question slightly differently, because it's the damages that you're seeking, although the damages, that is the inaccurate quarterly reports, they flow directly from the contract, right? Are there damages that you're seeking based on the contract or based on fraud or the aiding and abetting or the other causes of action that are different than the damages that flow from the breach of contract claim?
Well, so there's two separate fraud claims. There's a fraud claim a direct fraud claim that we're asserting against the Syncora entities, which, if we're looking at them separately, they're not a party to the contract. So I don't think that issue necessarily applies. With regard to Swap Financial Group, we also are asserting a direct fraud claim against them. But to boil our argument down for you on the Swap Financial Group, the breach of contract here is the failure of Swap Financial Group to pay Principia the amounts that it's owed. Principia was owed specific sums of money, and it didn't receive that.
But that sounds like a viable breach of contract claim.
Absolutely.
Which you still have,
yes,
right?
We do. We do still have that, absolutely, going back the 6 years to the statute of limitations. But the fraud here is the repeated misstatements in the quarterly reports, as well as the other misstatements that we described that have nothing to do with the quarterly reports.
Well, I don't see why that's not duplicative of the contract claims.
I'm sorry?
I don't see why the fraud claims are not duplicative of the contract claims.
Well, the fraud claims as to SFG are not duplicative of the contract claims because, yes, there was a requirement in the agreement that SFG submit quarterly reports within 7 days of the end of the quarter, and that was done. But the fraud here is the thing that induced the reliance. Misstating and failing to disclose to Principia all of the revenues that SFG made off of Principia's product. Yes, that was in the quarterly reports, but that was also in statements that were made separate and apart from the quarterly reports in 2015, 2017, 2018, and those allegations were all detailed in our complaint.
Yeah. Thank you, counsel.
Good afternoon, Your Honors. May it please the court, Matthew McDonald for Swap Financial Group. This is a textbook case of a duplication of a contract claim into a fraud claim. The contract that's alleged here is to license certain tech by the defendant, Swap Financial, from the plaintiff in exchange for, among other things, a share of certain revenue, which would be disclosed on quarterly reports and then paid thereafter the appropriate percentage. The fraud is alleged to be, and the breach of contract is that certain revenue was omitted from those quarterly reports and thus the fee is not paid. The fraud is the same contract was entered into, the same quarterly reports were issued, the same revenue was omitted from those quarterly reports, and the same underpayment made. There is no daylight between these claims at all. If we look at MBW advertising, where this court discussed the standard for dismissing a fraud claim, in which it says, well, we recognize that the same acts which give rise to a cause of action for fraud may also form the basis for a breach of contract claim. A cause of action for fraud will not arise if the alleged fraud merely relates to the breach of contract. It doesn't just relate to this breach of contract, it is this breach of contract. There is no daylight. The damages are the same. And that permeates through the case law. There's some discussion in the briefs about some side issues that frankly have no bearing. One is there's a line of cases that talk about special damages, which, as I believe was talked about a moment ago, don't exist here.
Syncora is not a signatory to the contract between Swap and Principia, right?
No, Your Honor, but I don't represent Syncora. That's my
Yeah, no, I understand, but that's probably why they want to bring him in, right?
I mean,
I know the damages are not, are collateral extraneous to the contract, so it's going to be difficult to sustain like they did in the federal court. So I think we've heard plenty from you.
Okay, thank you, Your Honor.
Thank you, counsel. So they want to bring you in on some claim, right? Because they claim you dominated or you have something to do with the material representations in the quarterly report. What say you?
Exactly, Your Honor. May it please the court, Joshua Kipnis on behalf of the Syncora entities. And you're right that this case is at core a straightforward contract dispute between two contractual counterparties, Principia and Swap, based on alleged breaches of an agreement that they entered into back in 2004. Notwithstanding that, Principia decided to tack on alter ego and fraud claims against the Syncora entities, who became the direct and indirect owners partially of...
you have 80% ownership interest in Swap, right?
80%, there's an 80% ownership interest that one of the Syncora entities has in Swap. That is correct, Your Honor. So all of the claims that were asserted against the Syncora entities were inadequately pleaded, and they were all properly dismissed. So first, starting on the alter ego claims, putting aside all the problems with choice of law that Principia faces here, at bottom, Your Honors are quite right that Principia has failed to plead particularized facts that would support complete domination and control. That's the first element. And Principia simply alleges, once it gets past all the information and belief allegations, that there are certain officers in common, that there's shared office space and email, and there's some shared payment administration. But as this court has held time and time again, these are routine features of corporate affiliation, and they do not give rise to an inference of...
But SIH, or Syncora Investment Holdings LLC, has 80% of Swap, right?
That's correct, Your Honor, at the time of the complaint.
And you heard all of the elements that counsel raised, including overlapping boards, individuals, etc.
Yes, this court has held many times, however, that common ownership, even some shared common officers, shared office space and emails, all of those things, they are common elements of corporate affiliation, and they do not rise to the level of complete domination and control that is necessary.
Were you part of the Southern District litigation?
We were not, Your Honor. We were not named as defendants.
So they were not able to get discovery, because I know that Principia got some discovery before the district court dismissed the breach of the fraud and misappropriation or trade secrets claim, right?
They did get discovery from the federal case from SWAP, that is correct.
So why shouldn't they get discovery? Because the Southern District did not, chose not to take auxiliary jurisdiction or invoke auxiliary jurisdiction. Why shouldn't they get some discovery in their state claims?
As to the Syncora entities, Your Honor?
Syncora. I mean, they got to try to figure out. I mean, you owe 80%. There's a lot of sort of superficial. I know that the elements, and you've heard the skepticism on the part of the court about whether they pled it sufficiently, but it's kind of difficult without any discovery, right?
Certainly, Your Honor, and a few responses on that. I also don't want to lose sight of the second element of the alter ego claim, which is that it was
we
used.
got the second element. Don't worry.
Thank you, Your Honor. Your Honor, the argument that was just made that shouldn't they be entitled to get some discovery, that's the exact argument that this court rejected 2 years ago in Art Capital Bermuda. And it held that the fact that a plaintiff doesn't have discovery at the time that it puts together its complaint and uses alter ego claims doesn't excuse it from being putting forth insufficient alter ego allegations. And in any event, there's no further discovery that they could try to take here that could transform what is fundamentally a breach of contract, which is what they premise this alter ego claim on, into the type of fraud or wrong that could support veil piercing. And they've obtained ample discovery from SWAP. They said they would love to use that in the case against us, and yet we have not heard a single piece of evidence that they say could actually make their allegations as against Syncora any better. And finally, there is this assertion in the briefs that Principia was somehow deprived of discovery here. But what they failed to note is that the court imposed an automatic stay of discovery while the motions were pending. They could have petitioned for additional discovery as against the Syncora entities. They did that against SWAP as well, but they simply chose not to do that. And they shouldn't be rewarded for that here, Your Honors.
Thank you, counsel.
Thank you, Your Honor.
Your Honors, I'd just like to pick up briefly on the discovery point and then address the direct fraud claims against Syncora, which I don't believe were addressed in the opening argument. With regard to the discovery, the federal court discovery was not available for use at the time that the motion to dismiss was made. As we explained in our papers, we understood that Syncora was likely to be making a motion to dismiss. Therefore, we deliberately served document requests early in the hope that this would give us sufficient time before the motion to dismiss was filed for Syncora to produce documents. The motion to dismiss had not been filed at that time. The deadline to produce documents came and went, but Syncora did not produce documents. So we had no Syncora documents to rely upon. And then just turning to the direct...
In fairness to them, they were not a party to the Southern District litigation, right?
I wasn't talking about the Southern District litigation. Just now I was talking about this litigation.
The discovery here, okay.
Yes, exactly. That's true. They were not parties to the Southern District litigation. And with one more point on discovery that I think is important is, yes, we had gotten discovery from SWAP Financial Group in the Southern District litigation, but the protective order that was in place in that time prevented us from relying on that information or referring it to in any way in the motion to dismiss papers. So we were fairly hamstrung on that point, both by SWAP Financial Group and by the Syncora entities in terms of getting discovery. And then just, again, I think one point that we haven't discussed here is the direct fraud claim that Principia asserted against Syncora. We have this alter ego argument, but then we also separately have a direct fraud claim argument. The trial court looked at this issue almost entirely.
But the reason the court did that is, and I'm sorry to interrupt you because you're running out of time, you ran out of time, is because the court saw the lack of particularized allegations that needed to be part of that direct claim, right?
Well, I think those are two separate standards, Your Honor.
They are, but not really, right? You still need to make very specific statements or particularized statements of facts about how you think they either dominated or participated in the scheme or did anything untoward or engaged in any conduct separate and apart from was contained in the breach of contract claim against SWAT.
In order to allege a direct fraud claim, one must allege particularity, the who, the what, the where, the when, the how of the particular fraud. We allege that. It most certainly can be the case that Syncora could, on the one hand, not be an alter ego of SWAT Financial Group, but on the other hand, have knowledge that the statements that it was making were not true. And the pleadings that we articulate, which go to the dual roles of the speaker in Syncora and SFG, how this person twice attempted to renegotiate the agreement on behalf of, we're not sure, either Syncora or SFG, and the fact that the company had been acquired and presumably had gone through a due diligence process. These are all elements that support knowledge.
Okay, thank you. Thank you all. Great argument. Almonte versus Edgecombe Properties and 535 Face. Okay, let me hear from Appellant.
I'm sorry, I'm really Good afternoon, Your Honors. My name is Lester Channon from Farber, Brox, and Zane. I represent third-party defendant 535 Phase Construction in this appeal of a partial denial of Phase's summary judgment motion in the court below. This is a case where a woman who was
Is there any question, no, we're familiar with the facts. Is there any question that the sand dust was present in the stairs?
I apologize. I have a mild hearing disability, with one broken hearing aid and one functioning one, and the masks make it even tougher. But go ahead. If you could.
Yeah, no, the question is whether there is any question that the sawdust was present in the area where the plaintiff fell.
Is there any question as to whether there was sawdust? Yes,
right.
Certainly, yes. In fact, the plaintiff herself testified she didn't see it, right? That's the quote. I didn't see. Did you fall on sawdust? I didn't see it.
But her boyfriend took photographs. Her boyfriend took photographs which depict sawdust on the stairs. Is that correct?
No. The boyfriend took photographs that he did not submit and are not in the record. They failed to put it in. They submitted a full deposition transcript minus 21 exhibits, even though the photographs that he supposedly that he produced at the deposition at the last minute, only a month before the close of discovery, were discussed 100 times. They didn't even bother to submit them. They say, well, we should have submitted them then, but the photographs that are in evidence that plaintiff produced show no sign of sawdust whatsoever. And
but Abreu's testimony is that he saw the sawdust 2 days before the accident. And then he took photos that you say you didn't see, but the testimony will be sufficient, wouldn't it?
Well, I would, there's a rule that says if a plaintiff's deposition testimony is contradicted in a circumstantial evidence case, Abreu did not see the accident and merely testified that there was sawdust on the ground, which she didn't see, which the photographs prove were not present, because she admitted that the photographs that are in the record look no different from what was on the ground or whatever, the conditions on the day of the accident, although she initially said that she wasn't sure.
Well, that's the point, sir. In other words, we know that the two photographs you rely on, 415 and 416 of the record, were not taken on the day of the accident, correct?
We're not what?
They were not taken on the day of the accident.
No, that's not necessarily the case at all. They're saying
don't know.
there's no proof of that, but she does say that in a follow-up question after initially saying she wasn't sure if it fairly and accurately depicts the conditions that were present in the day of the accident, she was asked a follow-up question right after that. Well, does it look any different in the photograph than it did then? And at first she said, I'm not sure. And then she said immediately, I think not, quote unquote, I think not. So
let me ask.
That's an admission right there.
So I'm sorry. Let me ask you another question. Exhibits A through U, which were the 21 photographs that were discussed during the deposition of Mr. Abreu, they were turned over to you, weren't they?
Yes.
So you had the same photographs in your possession so that if you believe that those photographs clearly showed no sawdust, you could have submitted that together with exhibits A and B, which were on 415 and 416 of the record, to sort of like hit the home run, but you didn't.
I guess I wasn't aware that I could augment the record, so I didn't, since it wasn't in the court below, my understanding, I guess somewhat limited understanding of appellate practice was that I'm stuck with what was shown to the court below and what the court ruled on. If you'd like, I can tell you what my thoughts are about those photographs.
No, but
yeah, that's not before the court.
But the whole point is, all that happened was that you would deny summary judgment. The dispute, I take Mr. Abreu's testimony alone, the photos alone, are sufficient to create an issue, a triable issue of fact. You may be able to convince the jury that somehow the apartment door was not kept open, that there was no sanding of that apartment D,
yeah.
Yeah, that apartment D, and that none of that stuff happened. But we can't find that as a matter of law.
Well, why is there a principle that says that if the plaintiff's son submits an affidavit that is self-serving and contradicts the plaintiff's prior deposition testimony, or a coworker or anyone else who submits testimony or evidence that contradicts the plaintiff's flat-out statement, no sawdust on the stair, why isn't it being disregarded by the court as a matter of law?
Well, see, what happens is that we can disregard it because we cannot make findings of fact with respect to who's telling the truth or not. That's a jury function. The court is to decide the legal issues. Here we have two competing witnesses saying that something was present in the stairs or was not.
Yeah,
because to make the argument and present the evidence to the jury, but not to us.
Yeah, because certainly there's also conflicting testimony between.
I don't quite understand you. I apologize.
No worries. Let me start again. There is also conflicting testimony between Abreu and Forsythe regarding the presence of sawdust. So those conflicting versions, that raises credibility issues. Would you agree that when you have issues of credibility, that's to be determined by the jury, not by the motion court on a motion for summary judgment?
So where does the principle of feigned facts come in where it's proven?
I'll tell you where. I think that's a phrase that's used traditionally.
Yes.
That makes no sense because every testimony that you submit in your behalf is by definition self-serving.
Of course.
The question is whether it's least to prove a particular, what you purported to prove. So it may be a feigned issue, it may be self-serving. The jury will decide whether that's the case or not, but we can. So let me hear from the other side.
Oh, I apologize once again.
That's okay.
Missing my cues.
Good afternoon, Your Honors. Morgan Corley from Cholman, Glazer, Corley, and Lickman on behalf of Angela Almonte. Now, I do want to just draw to the court's attention the fact that this argument about Mr. Abreu's testimony creating a feigned issue of fact was not raised in the underlying motion papers. In fact, Mr. Abreu's testimony was annexed to our opposition papers, and it was not addressed in Faye's reply papers. It was not brought up on the...
Well, they argued that it was contradictory, incomplete, last minute, uncorroborated, and self-serving.
Right.
Your Honor,
So,
it is...
I mean, all of that together may constitute feigned. I mean, you know, the totality of that may be feigned.
Your Honor, they actually don't talk about Mr. Abreu's testimony at all and how it contradicts the plaintiff's testimony in the underlying papers, but I do want to draw your attention to the testimony...
Well, because she stated that she did not know how she fell, and he came in and said that, you know, she must have slipped because there was sawdust, because he saw sawdust on the stairwell.
Yeah.
Yes.
So, I mean, to that extent, they do argue as to how it was contradictory.
But you heard the court's points about how its role is limited in this context, right? So I wouldn't spend a lot of time arguing that.
No, I agree, and I'm not going to belabor the point. I just wanted to bring to the court's attention that the one piece of testimony that Faye is relying on, where Ms. Almonte said at first she was not sure, looking at these photographs, that she testified she did not know when they were taken, so we cannot say they were taken on the date of the accident. She continued to say she does not know if the photographs depicted these stairs, and then the testimony is unclear as to whether she's being asked about the layout of the building or the condition on the steps. And there's actually, I'm just going to read you the testimony just to make it clear. Question, do these pictures fairly and accurately show the way the stairwell looked on the day of the accident? Mr. Belvin, note my objection in terms of the layout of the steps. Answer, I'm not sure. Question, do you remember it looking any different than what is shown in these pictures? Answer, I don't remember, I think not. And then counsel went on to question her about the layout of the apartment building and never asked about conditions, never asked about if the steps looked the same in terms of no lack of dust.
We got that.
Yeah. So that testimony is not a contradiction. It actually is in accordance with the testimony that she's not sure what she slipped on, which Mr. Abreu also said plaintiff was never aware. Plaintiff testified that when she went to the hospital, she first learned about the sawdust from Mr. Abreu while she was there. And Mr. Abreu is the only witness in this case that actually has knowledge of what the stairs looked like that day, as both the plaintiff and Mr. Forsyth did not look at the steps and did not see what condition existed on the date of the accident.
Okay, thank you.
Thank you.
Okay, counsel, I'll give you a minute.
Well, I have to be totally frank with you. I understood about 10% of what she said, but as to what I did understand, and I apologize for that.
No worries.
Yeah, so these masks are really an impediment.
They're difficult, I agree.
Yeah. Okay, so as far as the testimony of the plaintiff about the photographs, there's somebody, one of the attorneys interjected in terms of the layout of the steps, you know, and then she said, I'm not sure, do you remember it looking any different? I don't remember, I don't think, or I think not. You know, it's the fact that somebody interjected some kind of a comment in the middle of a question about whether they fairly and accurately depict the condition of the stairs as of the time of the accident doesn't change the flavor or the intent of that initial question and the follow-up questions after it, in my view. I don't know if there are any other points Your Honors would care to raise with me that were raised by my adversary, but
I think we're good.
okay.
Thank you. Thank you both.
Thank you.
And last, Gibson Dunn.
May it please the court. Mitchell Carlin for the judgment creditor, Gibson, Dunn, and Crutcher. Your Honors, we have two appeals today.
We're quite familiar with the record. I was expecting to see your opponent to justify why you haven't been paid.
That would have been interesting, Your Honor, but there's been, this is not in the record, Your Honor, but it's in email traffic with the clerk of the court that Mr. Shapiro had asked that he be permitted to argue by Zoom, and there was There were some
So,
exchanges.
we're quite familiar with the legal issues.
Okay.
I know that, you got the arbitrator's award. I know that there was some challenges
Yep.
to it.
I'm content, unless your honors have questions about the judgment debtor's appeal, which I would be happy to answer if you do. I'm content to rest on the briefs as to
Yeah,
that.
no, I think we're good. I think we're
Okay.
quite familiar with Article 52. We're familiar with the error that was made below with respect to whether you are required to make a motion or start a new proceeding. Clearly, 5225B doesn't require someone who you have jurisdiction already.
Right.
I mean, the whole idea of starting a new proceedings against somebody you don't have jurisdiction over.
Correct.
So you already have jurisdiction over them, so they're not a third party, so
Very good.
we're good to go.
So, your honors, if I may then use one more minute. On our appeal, once we get past what we submit was the error below in dismissing our motion and our application, the question is what happens now? We have respectfully submitted to the court, to this court, that the application and the motion that was made below that has not yet been ruled upon should be granted.
Yeah, you'll see our decision, but generally, the practice of this court is to remand to the trial court.
All right, Your Honor.
For it to do something consistent with what we instructed. So that's likely what we will do in this case.
Okay, Judge.
Okay.
I hear you. Thank you, Your Honors.
Thank you so much, counsel.
Thank you.
They're staying for sure? They're staying for sure? I mean,